Yes, we ready. Start. It was observed that the subsequent written statement filed by the appellant and evidence contradicted the stand taken by the parties at the time of filing of the divorce petition, and the first written statement, which was ignored by the family court. Stop. The court observed that it is true that after filing a written statement, no further written statement may arise at the instance of the defendant by way of a procedural right, except with the leave of the court and upon such terms as the court may provide. Stop. At the same time, that fetter placed on the procedural right of the parties did not prevent the learned court below from itself requiring additional written statement to be filed if that appeared necessary to it to dispensed to justice. Stop. Since 3 years had passed since the filing of the divorce petition, the court observed that the family court ought have sought a written statement from the appellant regarding subsequent developments. Stop. It was further held that since there was lack of proven facts stated in the plaint and the first written statement, the family court could not have granted a divorce decree. Stop. The court observed that Section 13B of the Hindu Marriage Act provides that the petition for divorce by mutual consent must be decided within 18 months of its presentation unless it is withdrawn by the parties in the meantime. Stop. Reliance was placed on Suresh Devi versus Om Prakash, where the Supreme Court held that for granting a decree of divorce under Section 13B of the Act, there must be mutual consent of the parties, and the court shall be satisfied as to the bona fides and consent of the parties. Stop. It was held that where there is lack of mutual consent, the family court has no jurisdiction for granting a decree of divorce. Stop. A decree of divorce at the instance of one party without the consent of the other party is not divorce by mutual consent. Stop. The bench comprising of Justice Sumitra Dayal Singh and Justice Donadi Ramesh held in granting the divorce on the strength of mutual consent. The learned court below may have dissolved the marriage between the parties only on the event of that consent continuing to exist on the date of the order being passed. Stop. Once the appellant claimed to have withdrawn her consent and that fact was on the record, it never became open to the learned court below to act on that withdrawn consent belatedly. Stop. In any case, it never became open to the learned court below to force the appellant to abide by the original consent given by her, that to almost 3 years later. Stop. To do what would be travesty of justice. Stop. Here it may be noted no money was paid to the appellant by way of permanent alimony etc. in lieu of her consent. Stop. The court observed that while the appellant gave her consent on 1/4/2008 and 25/4/2008, 18 months had elapsed and thereafter she withdrew her consent in February 2011, which was ignored by the family court while passing the decree of divorce on 30/3/2011. Stop. Holding that on the day of decree there was no consent on behalf of the appellant wife, the court set aside the decree divorce. Stop. The case was remitted back to the family court to proceed in accordance with law. While hearing a batch of pleas against bulldozer actions in various states, the Supreme Court today passed an interim order that no demolition should take place in the country without its permission. Stop. The court, however, clarified that this order won't be applicable to encroachments on public roads, footpaths, railway lines, or other public spaces such as water bodies. Stop. till next day. There shall be no demolitions without seeking leave of this court. Stop. However, such order would not be applicable for unauthorized constructions on public streets, footpaths, abutting railway lines, or public spaces. The court ordered stop.